Hi, we're going to get started. So we have a lot of faces that are returning from last week. This is the second week for the fundamentals, for the hot topics in land development seminar series. I am Victoria Ballestero. I'm a professional engineer with HTCS, and I'm really excited to be back here moderating this lecture series. Last week we kicked off the lecture series with a talk from Kevin Shepard, Esquire, and from David Thaler. And we're going to continue this week digging into some of the hot topic issues in land development. And I'm really excited to announce our first speaker tonight. We flew him in from across the pond. And actually, before I introduce them, for those of you who have never been here before, the bathrooms are around the corner. Very important, so please feel free to either go out the back, be careful with the door because it's noisy, or go out on the side door. If you need drinks, we have some drinks and food in the side room over here. So yeah, I think that covers our housekeeping stuff. So without further ado, I will introduce our guest speaker, our first guest speaker this evening. I'm not kidding when I say he just flew in from London via Venice. And so we're very fortunate to have Michael Powell here with us this evening. He is a managing member of Gordon Feinblatt, and he is one of the preeminent attorneys for environmental land use here in Maryland and in the United States. He has been nominated a best attorney, let me make sure I'm getting the name right, he's been nominated Lawyer of the Year and one of the best attorneys in America several years running. He has represented an array of corporate clients on environmental issues, and he's going to talk through all of the nitty-gritty and dirty issues that come down with the environment and land development here in Maryland. Without further ado, Michael Powell.
I know she said I just flew in. Isn't the standard joke to say, boy, my arms are tired? I think actually all of that was just to explain why I'm severely jet lagged, so bear with me a bit here. I was actually in Italy on Friday, in London on Sunday. I'm going to go through, what I've got is a set of slides that's sort of intended to sort of cover the whole continuum of environmental issues that you may run into in developing properties. But I'm going to try to use that as a springboard to talk about some of the issues that are most controversial right now. And as you can see from this slide, the kinds of things you can deal with environmental, I don't have to tell you, for a land development project is a long list, and it's getting longer daily. Years ago, back in, I guess it was 83, that I first went to work for the Maryland Department of the Environment, and then it was fairly straightforward if you want to develop a site in terms of the environmental issues. It is much longer now, and I have to tell you that list is going to get even longer. I'm going to talk a little bit about due diligence, because though I think this is an area where I see a lot of real estate professionals who think they understand due diligence completely. And really they don't, okay? Because you'll see an occasional case come along where everything goes off the rail over that issue. Brownfields I'm going to talk a little bit about, because again, this is a complex area. Many of you may not have an issue come up with brownfields, but if you do, you need to have a basic understanding. Wetlands and forest conservation are a couple of areas where there clearly are hot topics going on right now, where you may see some changes come through. Critical area I'll touch on. I think that's not something that you're seeing a lot of hot topics or discussion on now, but make sure you got the background on it. Nutrient trading is a big issue that issues are starting to come up now. You're going to see a lot of that over the next 5, maybe 10 years start to really impact land development. And finally, climate change, which is on the horizon. It's going to affect you. It's not affecting you yet. And I'm not talking about rising sea levels. I'm talking about regulatory requirements that are going to be imposed on you because of climate change. So let's go through these. Due diligence. I think people start with saying, well, due diligence, that means I got to look at the piece of property, have a consultant do a phase 1 and phase 2. It's important to understand why that comes about. What is the basis of that? Now, you've all heard of the Superfund law, which technically is called CERCLA. the Comprehensive Environmental Response Compensation and Liability Act. What that was a statute passed during the first of the controversies over environmental issues, when we had Love Canal and sites like that, where the government looked around and said, we got all these contaminated sites, heavily polluted, and we, the government, don't want to spend our tax money cleaning them up. We want somebody else to do it. So what CERCLA was a scheme to make sure somebody else cleaned up all the sites. And it became very clear very quickly that the people who had contaminated the sites did not have the resources to clean it up, right? Those chemical companies were bankrupt. The companies that had built munitions during World War II went out of business when World War II ended, but now the munitions were sitting out there in a field somewhere. So Congress decided in its wisdom, no, the people we're going to make clean up all these Superfund sites is anybody who had anything to do with that piece of property. In particular, owning it, but maybe some other involvements in it too. Maybe that they just transported some stuff there. If you approach Superfund by thinking what justice and fairness in the American way would require, you will be guaranteed to get the answers wrong every single time. Because this has nothing to do with fairness or the American way. It has to do with whose pocket it comes out of. So you can quite easily buy a piece of property, have no idea that there's contamination on the site, have nothing to do with that contamination, and have the department come along and say, guess what? Here's the bill for $150 million to clean it up. And yes, the contamination dated back from one of those munitions dealers in World War II, but we're going to come after you on it. So it really was a situation where we started to see the real estate market seize up, okay? People were afraid to buy pieces of property because what would the liability be? And nobody really knew what kind of investigation would satisfy the agency to say it's clean. Because you can never, look, you guys have looked, I'm sure, at a lot of phase ones. I've looked at thousands of them. There are a number of major builders who have me look at every phase one, phase two they do in the Mid-Atlantic region. And you can never know that everything that could be found about a piece of property was found in that piece of property. So what you're talking about is, what is the standard for due diligence, where we say if you've done that much investigation, we'll say that you did enough investigation. So Congress came along and amended the CERCLA to create something called innocent landowners. And the first thing to recognize about this is innocent doesn't mean what you and I think it means. If you had nothing to do with the contamination, that may not be enough to make you innocent. It's the minimum to make you innocent, but it's not enough. You got to have done the due diligence required by the statute. In practice, what that means is something called all appropriate inquiries, which is the kind of investigation set up by industry standards. There's a group called the ASTM, the American Society for Testing and Materials, that has developed a standard for what kind of inquiry will satisfy people that you've done enough to have due diligence. And it's from this standards that we got the phase one and phase two. And again, you can be innocent in the normal sense of the word, but not an innocent purchaser if you haven't done a phase one and phase two that meets the standard of the statute. And that's what's important, meets the standard of the statute. So for example, a phase one has to be done by an environmental professional. Environmental professional does not require a license. A license can qualify somebody for environmental professional, but they can also say, I've got enough experience, and so I am an environmental professional. I have seen many phase ones done by somebody who had worked for Department of the Environment, Department of Natural Resources. They say they're an environmental professional, then they don't understand what ASTM is. And I'll tell you a story about this, and I'm going to come back to it. I know somebody once, a major builder, and they came to me and said, we have this development, we've already put in about half the houses. Another major builder was buying the next phase of the development, and they've backed away from it because they said there's arsenic in the yard. And we're worried that we sold all these houses to look at already, and why is our property different than theirs? And I went back and looked at the phase 1 and looked at the investigation. If you look at the aerial photos for that property, you can see that yes, it was agricultural, and a good bit of it was orchards. Now, if you look at the ASTM standard, the presence of an orchard automatically triggers a phase 2 because orchards were heavily used pesticides, okay? So though row crops might or might not have some arsenic levels, orchards almost always did. The client had a phase 1 done by somebody who was an environmental professional in the sense that they had experience. They had recognized the orchard was there, but in their opinion, didn't require any investigation. Clearly wrong, okay? There are a lot of judgment calls in phase 1s, right? You can look at a phase 1 and say, is this really an issue or not an issue? But an orchard's an automatic, okay? So the consultant had clearly made a mistake. The client came to me saying, can you sue this consultant for me? And my first response was, give me the contract you signed with that consultant. In the fine print at the end, at the back of that document, it said, if we make a mistake on your phase 1, our liability is limited to refunding to you the fee that you paid us for the phase 1. We had about 30 houses that had been sold with high arsenic in the yard, okay? The fact that the client had a phase 1 in their hands that said there was not a problem didn't save that client a bit, okay? I actually inquired, why did you pick that consultant? I think the answer was that one of their vice presidents played golf with him every Saturday. So there is consequences if you don't have the right consultant and the consultant's not doing the right work. And one of the things you have to do is look at the consultant's credentials. How long have they been doing this? Is this a sideline, right? I see some consultants out there, they're really lead paint consultants, okay? But they'll tell you they'll do your phase 1. There's a little difference between looking at whether fly ash was disposed of in the corner of the site versus whether these buildings at one time had lead paint on it. And don't be afraid to look at the language of the contracts with the consultant and push back. I see again and again, particularly smaller builders, I signed the proposal when they said them. No, I didn't read that 2 pages of fine print at the back because I figured that's just boilerplate. My experience is that if I've got to repeat work with that consultant or I got a fairly large contract, I can get the consultant to make changes to that. For example, a lot of consultant contracts will have that language saying, my liability is limited to the fee that I've paid you. Typically, what I go back to them and say, no, I want your liability to be limited to your insurance that you have on this site, and I want a certificate of insurance saying what you've got coverage, okay? Usually can't get it to be unlimited liability, but I can get that much. And if a consultant won't give you that, you got to sort of wonder why, because they're not going to stand behind their work. The other thing is that when you look at that language, who owns the report, okay? It's very common for a consultant to say, this is my report and nobody else can use it unless they pay me an additional sum, okay? Then you got to get something called a reliance letter. So what they're going to do is if your lender comes in and says they've got to have an environmental consultant report, or your buyer says I've got to have a report, or the buyer's lender says I got to have a report, that consultant's going to say, not unless you pay me another fee. And you know, you've already paid for all the work. One of the things you can do is push back and say, you know, I want to be able to be fair use. If I got a buyer who wants to rely upon that same document, you'll agree to give a reliance letter so that buyer can do that. Even with all of that, look for data gaps. Almost every phase one I've seen has a section in it called government records. And it's required by ASTM. And what that is they go to the government agency and say, do you know anything about this piece of property that I should know? Or the immediately adjacent pieces of property I should know? Now they check computerized records. There are often these lists. Every underground storage tank that leaked in the area. Every known hazardous waste landfill in the area. But not everything gets into those computerized lists. And so it's very common for the consultant to then go to the agency and say, I want to know what you've got. Do you have any documents, any files related to that? The agency says, submit a Freedom of Information Act request. You come to your consultant and you say, I got to close on this. My due diligence runs out in 30 days, and the agency is going to say it's going to take 45 days to respond. So you got to make a decision. And very often the consultant just writes the report, identifies it as a data gap. Says, I don't know of any environmental problems on this piece of property. Then there's a section called data gaps that say, I don't know whether there's anything in the agency files, and I'm not responsible if there is. Okay? Very frequently you have to live with that. But you need to make sure you look at it, have a conversation with the consultant and say, what is the chance that there really is something there that you missed, right? If you're looking at a piece of agricultural property in a field, it's a good chance the agency is not going to have any documents on it. If you're looking at an industrial piece of property in East Baltimore, I'd want to see those documents before I made the decision. So focus on that and think about that. Make a conscious decision if you're going to decide to take the risk. Because even if you've met the ASTM standard and you're an innocent landowner, that merely means the government agency can't come and ask you for that $150 million or whatever. But it doesn't mean you got a piece of property that's worth what you paid for it, right? I've seen clients, they come into me and they say, look, I did the investigation, here's a phase one, it met every standard. Absolutely right, they're not liable. But nobody's going to buy that piece of property. And in the meantime, the seller's gone somewhere, right? So the money's gone. So you really need to concentrate on whether the phase one really gives you confidence in the piece of property. I don't want to scare you too much, because most of the time, probably 90% of the time, a clean phase one is a clean phase one. But the large builders will have an environmental lawyer look at those phase ones like myself and give them a review, simply because those few rare cases where it's a problem, it can be a very big problem, especially if you've already started building on it. Now, phase ones are designed to look for what's called a recognized environmental condition, or REC, R-E-C. So what a phase one does is it says, I'm looking at the records, I'm interviewing the people who are there, I'm looking at the computerized results, I'm looking at old aerial photos, I'm submitting a request for documents from the agency to see, is there something that looks like it needs additional investigation? Again, no guarantee that you will, but is there something that is a recognized environmental condition which should be investigated? If something is identified that is a REC, then the consultant under the ASTM standard has to go to a phase two. And phase two is basically, we've got to resolve that recognized environmental condition. We've got to say, is it really a problem for the proposed use of the property, or is it just an apparent problem that we had to investigate? Generally, that means sampling, right? I already mentioned orchards. If you have an orchard on was on the property at some time in the past, the case I mentioned, I think it was back in the 1930s, then it's going to be triggering as an environmental condition. The answer is you go out there and sample the soil and say, is there a high arsenic level or not? You need an experienced professional even to do that. I'll tell you a secret about orchards. The arsenic level is not evenly spread. There's something called a drip line. right? Imagine a tree, an apple tree or something like that. There's the edge of the leaves. That's where the arsenic accumulated, and that's where you'll find the highest level. If you're buying this piece of property and you haven't closed on it yet, you want to know what's at that spot, not what's off at the edge of the field or immediately under the tree. Under the tree can be bad, but the drip line is going to be worse. But anyway, you need to design a phase 2 that addresses the phase 1. Phase 1, there's a whole long list of these are the things you must do. Phase 2s are designed case by case. Nobody can tell you this is what a phase 2 requires other than usually sampling, because the sampling plan and what's required has to be designed to address the wreck. You're also going to see in recent years, 2 other terms have become common, historic wreck and controlled wreck. What those are, a historic wreck is one where there's a historic condition that clearly was a recognized environmental condition, but it looks like it has been addressed. A perfect example, a leaking underground tank. So at some time in the past, there was a gas station here. Gas stations are automatically a recognized environmental condition, but 10 years ago, somebody came in, cleaned it up, and got the Department of the Environment to sign off to say it was clean. So there historically was a problem, but it's been addressed. Controlled wreck. Controlled wreck is there is an environmental problem. The environmental problem still exists on the property, but there's a mechanism in place to control the problem, and so it is now safe to develop. One of my clients was the old Honeywell, which is the successor to the old Allied Chemical. Much of East Baltimore is built on controlled wreck sites. That is, there's chromium contamination in the soil, but we put a cap on top of it, and all the agencies have agreed that as long as that cap is intact, there is no danger to people living on there, working on there, etc. So that's a controlled wreck. The chromium condition exists there, but it's controlled, so therefore it's safe to build. So all of this, phase 1 and phase 2, is all designed just to avoid Superfund liability. And you do have to check the blocks. But if you can't pass it, if you can't clear it, if you can't show that it's clean, we did adopt another program called the Brownfields program to try to address the situation where there is an environmental problem. We can't say it's controlled and we can't say it's been completely cleaned up, but you want to go ahead and buy it anyway. I was one of the authors of this program when I was Chief Environmental Attorney for the state, and it was a very controversial program when we put it together. But I think it's become an accepted program now, and it's used, much of Baltimore in particular is built on brownfield site. But even though this is my handiwork, and I do, I think, more brownfields work than anybody else in the state, I always tell clients, you don't do brownfields unless you have to. All right, this is a last resort. I can't eliminate the wrecks. I've got to deal with this situation. And typically what that means, you got to deal with it for one of 2 reasons. Either because you have a lender that says, I want a government agency saying this has been fixed. I want a government agency to say, it's clean enough. It may not be clean, but it's clean enough for residential or whatever your proposed use is. Or you want tax credits, okay? And I'm going to come back to the tax credits, but that is a powerful incentive for brownfields. There's 2 programs that make up part of the brownfields. The first is the voluntary cleanup program. The second, which is the tax credit, is the Brownfields Revitalization and Incentive Program, or BRIP. Let's talk about brownfields first, the voluntary cleanup program first. Here's where things get confusing. I talked a little bit earlier about innocent parties. Now I'm talking about something called inculpable parties. I'll tell you what that means. It means that late at night when we were drafting this statute, the first draft that I did called them innocent parties, and somebody pointed out that they'd be confused. Innocent parties means something different in Superfund than it means here. In those days, we had an old Wang word processor. Remember one with the green letters on the screen? And it had a built-in thesaurus. So we typed in the word innocent and it popped out as a synonym the word inculpable. So we wrote that in the statute. I've since, when I've given this speech, had people come up to me and say the word is really unculpable. And I say, go argue with Wang, because inculpable is what we ended up with. But an inculpable party can, if qualify for a complete protection from liability, even if they bought a contaminated property. It does not mean that the property retains all its value. It means that the government agency can't sue you or sue the lender if they foreclose on it for the cleanup cost. You basically earn the right to walk away from the property scot-free. But whatever you've invested in the program, you've lost. But that's why I say for lenders who say, I'll lend you the money on this, but I don't want to take any chance that I'm going to have to clean it up, it can be something that you need. The trick to inculpable status is, one of the things you have to demonstrate is not only did you not have anything to do with the contamination, but that you had no interest in the property and had never had an interest in the property. One of the things I see very frequently is people come to me and say, I just bought this piece of property last month and I want to go into the brownfields program now. I can't get you in as inculpable party if you've already closed and your name is on the title. Well, there are some loopholes I've used, but they're threading a needle, okay? It's very hard to. So if you're going to go into the voluntary cleanup program, you need to make that decision and lay out your plan before you close on the property and get your material together. And I'll come back to that because it has, well, let me go ahead and talk about it now. One of the benefits of the inculpable is if you're inculpable, there are significant tax credits that are available. And the tax credits are a little complicated, but they're automatic if you qualify. What the government does is to take the value of the property before you go into the program and the value of the program of the property when you get the final sign-off from the agency and there's an increase in the assessed value. You get a tax credit equal to half of that increase. In other words, if your taxes would have gone up $100,000, instead they only go up $50,000 for a period of 5 to 10 years, depending upon whether it's in an empowerment zone. It does not matter whether the increase was the result of your cleanup or your total development, okay? You can have a piece of property and it's just a blank piece of property in downtown Baltimore, nothing on it. You go in there and you find a leaking underground tank or a small area where a PCB transformer leaked. If you can time it right and get your hotel built before you get the sign off, then you can get a tax credit on the entire increase in assessed value for building the hotel. The trick is the timing can be difficult because you've got to convince your construction lender to allow you to take on the loan even though you don't yet have the completion of the voluntary cleanup program. But there are lenders who can see that. If I get a letter from the agency that says, we will give you the no further action as soon as you do 1, 2, and 3, and you can show the lender, we're clearly going to do 1, 2, and 3, and then we'll get it. You can sometimes work that, and as you can imagine, that can be a tremendous tax credit, and it's automatic. It is not discretionary. It's not a matter of you having to lobby whoever the mayor is of Baltimore these days. You get it automatically if you qualify. When you go in for remediation, a couple terms to understand. There's what we would typically call a no further action letter in this program is called a no further requirements determination, NFRD, or a certificate of completion, COC. What do those terms mean? An NFRD says basically, I went in and did enough of investigation to convince the agency that nothing needs to be done. I've convinced the agency that it really is clean. I had to spend a lot of money doing the testing, and I want the tax credit because I had to do a lot of that testing. And I get the tax credit as long as there was a perception that it could be contaminated, whether it is or not. I'll get the tax credit. But I did the investigation. I convinced the agency that nothing is required. I get no further requirements determination. Certificate of completion is we did the investigation. We identified things that needed to be done. And the agency agreed A, B, and C is what needs to be done. When I completed those, they gave me a certificate of completion. The legal effect of both of them are the same. It's the procedure you have to go through to get them. Under the NFRD, you develop a remedial action plan. Well, at NFRD, you get it if you don't do any investigation. If you can't get the NFRD, you need to go to the COC, develop something called a remedial action plan, or RAP. That basically, you get the agency to approve that. That's the ABC. I'm proposing to do ABC. You, the agency, agree that if I do that, I get the certificate of completion automatically. Get the certificate of completion automatically, I get the tax credits automatically. I mentioned some of this already. You get just about near immunity to liability. There's a couple of exceptions, imminent threat to human health, undiscovered, but it's pretty much automatic. A huge tax credit. You obviously can market the property as clean. There was a time when a lot of developers were afraid that there was a stigma. If I said this was a brownfield property, no one would buy it. I think it's a little more sophisticated now. And my argument has been, if I sell you this piece of property over here in East Baltimore that I've not taken to the brownfields program, you have something signed by a consultant that says it's clean. And by the way, the consultant probably has said the most you can get is a refund of your fees. But if I get a sign off by the agency that it's clean, the agency cannot come back after you and say, guess what, it's not really clean. So I think you can make a convincing argument that a brownfields property is safer than a non-brownfields property, that the risks have been addressed. Restrictions on it, though. A brownfield sign-off says you're protected from the government agencies. It doesn't say you're protected from third parties. If a neighbor says your property is contaminating mine, the brownfield certificate is not a legal defense. As a practical matter, it's kind of hard for the neighbor to sue you if a government agency says it's clean. Okay, so it's a practical advantage, but not a legal advantage. Now there's another program, the CHS, Controlled Hazardous Substance Program. This is how we used to do cleanups before we had brownfields. What has happened over time is that because the brownfields program ties the hands of the agency, right? If you go through that program, they agree we will never come after you to clean up that piece of property. In other words, if there comes to be a problem on that piece of property and we can't get anybody else, the government has to go clean it up. They can't come after you. So for that reason, the agencies look really hard at your environmental reports to make sure that they're convinced that it's safe. That has made the agencies feel more comfortable with the old way of doing it, the controlled hazardous substance, which where you get is not a binding commitment by the agency. You get basically an opinion letter, and no further action letter. When you read that no further action letter, it says, we've reviewed all your environmental information and we don't see any reason today why we would need to ever require you to do something. Now, in practice, it means more than it says. The agency almost never takes back a no further action letter and changes their mind, but they're not legally bound to it. If there's something come along tomorrow and they change their mind or the standards change, unlike the brownfields program, they can change their mind. But this program is much faster and much easier. So the trade-off is less protective, no tax credits, but faster and easier to get the development. Yeah.
What's the time difference?
The brownfields program, you're going to figure about 180 days, and it could be longer if you got to do a lot of testing. The CHS program, It's a little hard. It depends on how much the problem is. I've done them in 45 days, but I've also known ones that take as long as 180 days because you have a serious environmental problem that requires a lot of investigation. The other trade-off is, and I tell this to clients all the time, how tough do you want me to be with Department of the Environment? The cleanup plan under both of these is a negotiated document, okay? It's really not that an engineer can go flip open the textbook and it says we got to do A, B, and C. It's the agency says, well, we think you ought to do this, and I say, oh, we don't need to do all that, and it goes back and forth. I can negotiate harder, but the agency's got all the time in the world, right? So at some point there's a trade-off. Okay, I can push back on them, and it'll take us another 2 weeks. Another 3 weeks, is that okay with you? So it's a little hard to estimate, but clearly the CHS is much faster. Now, recently, within the last about year and a half, maybe 2 years, the department has really come up with a hybrid, and that's because people were complaining that the brownfields program gives me these tax credits, but look how long it's going to take me to get through the process. The CHS program, I can clean it up real quickly and get it done, but I don't get any tax credits. And so sort of the environmental bar, me in particular, but not only me, and the department sort of came up with, wait a minute, the statute allows us to do this hybrid where you file under the brownfields program and then you withdraw your application while you do the cleanup under the CHS and then go back to the brownfields program. Why do you do that? Because to be the inculpable status and get the tax credit, you got to start out in the brownfields program before you buy the property. And then you do the cleanup under the CHS and then you go back to the brownfields program. It sounds really weird, but it works in practice. I got a site in Baltimore right now. It's an old school, actually, and I mean a very old school. My father went there to elementary school, I think, and and there was a junior ROTC shooting range in the basement. And shooting ranges mean a lot of lead in the soil because it's a dirt floored basement. So we're taking that process because it's going to get us through faster. We're going to get the tax credits at the end of the day. So it works, but it is a complicated process. Okay. Let's keep going because there's a lot of topics here. Wetlands. Yeah.
What is the current regulation when a lender has to foreclose on a contaminated property, and what can they do? How do they defend themselves?
Yeah, there's a safe harbor, and I actually wrote the section that went into the state law. Then after that, federal adopted a federal harbor, and we went back and tinkered with the state law, so it just about matches. So let me describe the federal. In the old days, if a bank foreclosed on a property that was contaminated, the moment the bank foreclosed on it, the bank was liable. Not just, I got to give away the property, the bank's got to clean up the property, right? The same set of amendments that adopted the innocent landowner defense also said that if a bank is just acting to protect its security interest and nothing else, then the bank is protected from liability when it forecloses. It is complicated to make sure they stay on the right side of that line, right? Because you'll see banks that go, well, I got to foreclose on this property, I'm going to fix it up a little bit and then I can sell it, okay? And once they fix it up a little bit, they're acting as a developer, not protecting their security interest. The banks understand those rules pretty well. I've taught a number of seminars to them about how to do that. But it is something that scares them a bit because you got to stay within the edges of this line to be protected. And if you don't, they're the deepest pocket on the planet, okay? Let me come to wetlands. And you've all dealt with wetlands before. Let me give you a little bit of background on wetlands, why it's so confusing and so much controversy constantly about this. It's a case of a statute that was intended for one purpose and it gets adapted to another purpose. The original wetlands law said If you take dirt and actually it's even more sensitive to that. If you dredge in waters of the U.S., you have to get a permit for it. Right? You know, if you're going to go out there and you're going to turn that stream into a deep canal, you got to get a permit for it. And similarly, if you fill in that stream, you got to get a permit for it. We're waters of the U.S. In the original statute, it said navigable waters are waters that impact interstate commerce. It's very clear that when Congress adopted that, what they were thinking about is, wait a minute, the state can't come in and say, okay, we in Virginia say it's okay to block this stream, and you guys in Maryland who are downstream, that's just too bad. You got to go to the federal government to get permission to fill or dredge in navigable waters of the U.S. But in the 70s, and somewhat in the 60s, people got concerned about stuff being dumped into streams and waters, and they decided that wetlands were very important, and there was no statute out there specifically dealing with protecting wetlands. And so what has happened is, over time, the definition of what those navigable waters or waters used in interstate commerce means got expanded and expanded. I recall one case that said interstate commerce includes hunting for ducks. Therefore, any pond that ducks lie in is waters involving interstate commerce, and therefore wetlands cover it, and therefore you have to get a permit from the Corps of Engineers to fill a duck pond. And in fact, that's true. I had a client once who had a piece of property on the eastern shore, and it had been in the family for years. Nobody lived there. It was an old farm that had been grown up, but without his permission, people had gone back there and dug a duck pond to hunt the ducks. And so when he finally came to develop it, the inspector went out there and looked at it and said, no, there's a pond there. It's wetlands. You can't build there. And he said, it was trespassers that did it. Too bad. As soon as somebody dug that pond and there was a duck landing in it, it became waters of the U.S. So this obviously is something that has always remained controversial. One of the things to note is that though you'll see lots of discussion in the literature, and I'm going to talk about it, about waters of the U.S. and what the Corps of Engineers is doing and what the Republican and Democratic institutions, administrations keep doing and undoing. Because there's a Corps of Engineers manual that says how you decide what is waters of the U.S. What happens is every time there's a change from Democrat to Republican or Republican to Democrat, the manual gets pulled back and rewritten. So it goes all over the place. But Maryland also regulates these materials, and Maryland's rules have been pretty standard. So there may be issues about whether this is governed by the Corps of Engineers, but it's pretty much always going to be governed by Maryland either way. The question is whether it's also governed by the Corps of Engineers. EPA has consistently taken a very broad view of the term. Trump administration is promising changes to pull it back, as I said, every administration has. It's a little too early yet to say what's going to come from that. Wetland delineation, and I don't know how many of you deal with this a lot. I'll get clients who are new to the business and they'll say, well, how can that be a wetland? It's not wet, which sounds pretty obvious, right? But the definition of wetland adopted by the Corps of Engineers during the Democratic administration says being wet or dry is not the determining factor, at least not by itself. It's three factors. And it's not, all three don't have to be present, but it's a combination and assessment of the three factors. First, is it wet? Okay. Is it something that is saturated? Secondly, what grows there? Are these plants that typically grow in very wet soils? Okay, so that requires you to identify the plant. And this is something that likes to have its roots wet, or this is something that's perfectly happy with it dry. Roots. And then what is the type of soil? Does it look like the kind of soil that indicates that it's frequently wet or frequently dry? The reason I stress this is a judgment call, right? And I have many times seen a very good environmental inspector who's a wetlands expert and a Corps of Engineers inspector who's a very good Corps of Engineers inspector, and both of them are absolutely sincere, and they come to 180 degrees difference of opinion. So you can't be sure you know what these numbers are. Very frequently what occurs is the environmental professional you hire and the Corps of Engineers guy will walk the site and discuss it, okay? But that means you really got to look at the quality of the engineer you got doing the doing the wetland delineation, not only about in terms of their expertise, but their ability to deal with the Corps of Engineers and talk them into things, right? I've seen guys who are really good, but the Corps hates them, right? That's not necessarily who you want out there trying to persuade a wetlands Corps of Engineers expert. If it is a wetland, the question of what kind of permit you have to get is extremely important. If you've got a small piece of wetland impact, 1 acre or less, you can get what's called a general permit. A general permit really is just a regulation. What it does is it says, you give them a piece of paper that says, I agree that I'm going to be governed by that regulation, and that regulation will be my permit. Okay? I'll obey everything in that regulation, so consider me having a permit. An individual permit, when there's greater impacts, are something that has to be individually designed and is subject to public notice and comment. So an individual permit takes much longer period of time and requires you to have some negotiation. How much negotiation depends on how much of an impact you're going to have. Obviously, the key is you want to try to get your impacts down below that 1 acre and try to make it a general permit rather than a individual permit. Let's see here. I think we can skip this one. Maryland license. A lot of people get confused about this because they'll say, well, there's tidal wetlands. What's the difference between a Maryland license and a Maryland permit? It's not a big deal. I just want to make sure you understand it so you can see why the difference of nomenclature. A permit for a wetland is a permission to dig up or put soil on a wetland. A license is permission to use a portion of property that technically is owned by the state. In Maryland, the state owns the bottoms of all navigable waterways, all rivers, all lakes, etc. So if you want to put a structure in that, or you want to put soil in that lake and create an expanded area, you may not only need a permit for the wetlands, but a license from the state saying, we're going to give you an easement, basically, a permanent easement on to use that property. One of the reasons this becomes an issue is that licenses can only be issued by the Board of Public Works. That's the board in Maryland that consists of the governor, the treasurer, and the comptroller. And only they can issue the license. So you inevitably get a significant delay in time to get on their agenda. Yeah.
So in some cases, you'll have a property that falls in below the water line or the rack line, which is governed. Now, does that property, being that you own that property below the surface,
You may have
from that?
you may have a riparian right to use it, but to the high tide mark, the state owns it. And
Yes,
so,
but if you own the property by deed, do you need a license to adjust that?
the state believes that you do. And I've argued with them on that. It's most relevant. There are, if you look at Baltimore City land maps, they'll often include meets and bounds description that goes out into the water. And I've argued to the state that that gives me the permission, I own it. And typically what the state says, okay, we'll make it easier for you to get a license, but we still want you to get a license. All right, you can't go in there without the Board of Public Works approval, but the fact that you have that historically record makes it easier to get it, especially for things like piers. but you can't be sure to get it even then. I had worked back when Pat Turner was doing the Westport development, and we had wanted to put a small landing on that. And the federal government just said, we don't want you to do it because we have this policy against building anything in the harbor out over the water at all that's not already there. If you can show there was a historic pier there, okay, but not. We went so far as to say we'll do glass bricks so it won't put any shade down there. We will excavate enough of the soil so the total bottom of the harbor will be just as great. But in particular, Fish and Wildlife just says, we've got this policy against it. No, it's not written in statute. No, it's not written in regulation, but we're just not going to let you do it. So it's a peculiar area. But, and that was a case where on the title records, Pat did own that piece of property.
Is that only for filling or for filling and dredging?
Filling and dredging. Okay. I think I'm falling a little bit behind, so let me move ahead a little bit. Forest conservation. There is, Maryland has a Forest Conservation Act that basically requires a minimum amount of forest on any development. And it has, it applies, and it has a certain minimum that's required. Local ordinances may require more than the state minimum. It's applicable to pretty much anything you would do that impacts an acre or more. If you're doing sediment control, grading, project plan, subdivision, etc., you're going to have to get your Forest Conservation Act improvement. There are some exceptions. If your agricultural activity is exempted from it. It may be that energy projects are exempted from it. I and my colleagues do a lot of renewable energy projects, solar farms, etc. And we've gotten a ruling from the Circuit Court of Baltimore that you do not have to comply with forest conservation if you're building an energy project and get a permission from the Public Service Commission. That's being appealed now, and
Is that community solar or one of the other?
it's one of the community solar.
Community solar. Is that only applicable to Baltimore City?
No, it would have applicable anywhere. The history of that is the
That's
public.
That's not what we're seeing in other areas. We're having to provide forest conservation.
It's controversial, and the DNR doesn't want to concede it. Okay, this is the history of that. The generating station law for building power plants is, of course, a very old one, right? And when it was adopted, everybody's concern was nobody would agree to let a coal-burning power plant be built in their jurisdiction. So every county was saying, you can't build it in mine, but you had to build it somewhere. So the statute was written to say that if you go and build a generating station, which in those days meant a coal-burning power plant, then it overrode any other laws. And instead, the Public Service Commission decided what the environmental rules are. Doesn't mean that an agency can't come in and say, I think they need to comply with the forest conservation, but the Public Service Commission makes the decision, not DNR, okay? I actually first used that statute in connection with a waste-to-energy plant, but then we used it in this one where we said a solar farm is an electric generating station. So if we go to the Public Service Commission and get their approval, it should overrule any other agency or local government zoning rules, too. And as I said, we've got a ruling in our favor, but it's up on appeal, but we will see.
Special appeal?
Court of Special Appeals, okay? Actually, I'm trying to remember, a cert may now have been granted. I think while I was on vacation, I got a note saying that the Court of Appeals granted cert. I'll check that for you. It is a huge advantage. It doesn't necessarily prevent, you still have to go in and convince the PSC that it's okay to cut down these trees, but it's a whole lot easier to convince the Public Service Commission that's focused on making sure we have enough power plants than it is DNR, which all they care about is making sure you don't cut down trees. So it's a much more friendly venue. But I put a question mark beyond that because, as I said, it's not accepted. Okay. I'm running out of time, so let me go real quick. In forest conservation, you have to do a stand delineation. You have to say what trees are there and what you're going to do to keep them. It requires you to document what kinds of trees, what's involved. There are two things you might have to do. Afforestation means there are not enough trees on there even before I come on, so I'm going to have to plant additional trees. Reforestation means I'm going to be cutting down some trees, and so I've got to replace those trees or restore those trees. The standards are basically a 15 to 20% of the land has to be forested, or you can pay a fee in lieu. I've not included a slide on this because there's a bill pending in the Maryland legislature right now that has passed the House and has passed second reader in the Senate, and therefore I think is likely to pass, which is going to put some restrictions on the fee in lieu. Typically what has happened in these cases, if it becomes too hard to put the trees on your own piece of property, you pay a fee to the local government. The local government is supposed to use that money to go plant trees. In fact, what's happening is the local governments have accumulated this money and are not planting the trees. So the environmentalists went after them this year and said, we don't want these developers to get away with it by just paying money. We want to make sure that they actually pay for the planting of trees, and the trees have to happen. So they're going to put restrictions on you paying the fee if there is available something like a land bank that could plant the trees for you, and they're going to put restrictions on the county accepting fees unless they've got a plan that's being implemented to make the planting. So you may see some restrictions on that. I'm going to skip the critical area stuff because I think that's pretty settled right now. I mean, just think of it as a special zoning rule.
We're running out of time. The nutrient trading, which I don't think
Yep.
everybody understands, and that's a really hot topic.
That's what I was going to switch to. And it has something you'll hear called the Phase 3 WIP, WIP, and nutrient trading. Historically, the way we controlled pollution in water bodies, and if you want to go back, there's a slide called Introduction to Nutrient Trading. Is we said, what is the best we can achieve for technology? So if you had a sewage treatment plant and it was discharging to a body of water, we said, what was the best available technology for treating that sewage? And you set the standards based upon what's the best technology out there for treating sewage. But then they developed a different standard, which is in the original Clean Water Act, but everybody ignored it, which is something called a total maximum daily load. What that said is, let's ignore what technology can achieve. Let's say, what can the water body absorb? What is the most of something we can dump into this stream, this river, this Chesapeake Bay, and still have it meet fishable, swimmable, drinkable standards? So it basically was a diet for the Chesapeake Bay. And the key issues for Chesapeake Bay are nutrients, nitrogen, phosphorus, and sediment. Sediment is not itself a nutrient, but it accompanies the nutrients. So what happened then is you had to develop a plan for how you would reduce the amount of nutrients going into the Chesapeake Bay to a standard set by science, whether or not the technology existed. You just had to meet that standard. So this developed these watershed implementation plans, that's a WIP, where it said, this is what we're going to do to reduce the contamination. But because it ignores technology, it means that you couldn't simply go and have this sewage treatment plant over here reduce the amount of discharge by X percent, because it may not be possible for them to reduce by that much. Or go to this developer and say, I know you think you need this entrance road, but you can't pave it, because if you do, you'll have enough runoff that you won't meet our standard. So the idea was to develop a system for trading among themselves. So maybe you can't avoid putting that big, long paved road, but maybe the farmer next door could farm a little bit less and plant some trees. And so the farmer would reduce nutrients by enough to offset the amount of increased discharge that you get. And the reason it became complicated is there have been phases. I said this is phase 3. In the first phase, the Department of the Environment with EPA developed a plan for how do we have a plan, we don't reach it yet, a plan for achieving the TMDL standards, the diet, on current use of the property in current development. And there's a plan that on paper gets there. But in the first version of it, it was deliberate because they had to get started somewhere. It didn't account for growth. It said, okay, if everything froze today, we didn't have any other development, didn't have any other people, we didn't have any other cars. If we did this, we'd get there. But now you got to deal with the growth too. So that means that the trading program becomes even more important. You've got to find a way to offset that. This is something that we've in the state been working on for, I guess, 4 or 5 years now. I think I was a part of the original Accounting for Growth negotiating team for the business back in the O'Malley days. We never could reach a deal. But the reason this is important to you is they now have trading rules out there. Within the next 5 years, you're going to see people come to you and say, you can't develop that unless you go out and buy the credits from somewhere to offset the increased contamination that's going to come from your property. The easiest place to get it are farms. The farmers, even though they're the ones you're going to buy this from, the Farm Bureau hates this because they view this as a way to drive farms out of business. The only way you create the credits is for some farmer to plant trees in his farm. So the farm disappears and instead there are trees. So they view it as the developers are going to come in and not only take our farmland and build it on it, they're now going to force us to plant trees on the rest of it and the farm goes away. So it's going to be a very controversial program, but you're going to see again and again as this phase 3 WIP gets implemented that you're going to be required to go out and buy credits to offset the development.
What's the baseline?
The baseline, which has already been adopted in the original, I can't remember the numbers off the top of my head.
Is there any chance that if we do super duper stormwater management that we're going to be able to sell credits instead of buy credits?
In theory, what the regulations say is if you're doing best practices, that is required by the statute, and so you can't create credits that way. You have to go above and beyond what is required by law. And the problem is that since the O'Malley years, what's required by law in stormwater management is already way up here. So to go beyond it, in theory you can create additional credits. I have questions about whether it'd be economical to do so. The farmers are the low-hanging fruit.
ESD, let's just say, is 1 inch. You have to manage the first inch. I'm making
Yes.
If you manage 2 inches, can we, as developers, sell credits?
In theory, yes.
Ooh,
Yes.
you got my attention.
Yeah. You in theory can. You got to document it, and there is a process. Yes.
Is it within a certain watershed, or could I buy a farm on the eastern shore and develop a bunch of houses?
No, there is, and that's actually been controversial. I've argued that because we're talking about as a diet for the bay, that all the tributaries of the bay should be the same. But as adopted, it's a watershed by watershed trade. And if you go to the Department of the Environment website, you'll see that they have divided up the watersheds multiple times. We're not talking about 3 watersheds or 4 watersheds. We're talking about, I don't know, 10 of them or something like that. And so you will find that you've got to trade within your watershed. There are also factors, it's a very complicated equation, factors that have to be taken into account if what you're trading is in different proximity to the water, right? If you've got a piece of property here that's 5 miles from the tributary, it's not producing as much impact on the tributary as one that's right on the watershed. There are impacts for what's creating the credits. A sewage treatment plant that's got a point source, a reduction of this much gets full credit. If you're talking about a farm, there's an uncertainty factor that reduces it. It becomes a very complicated equation.
So if a farm has chickens on it, they have chicken waste, is that worth more than if it had corn or soybeans on it?
The chicken waste is going to be worth less because you get a lot more nutrient runoff from the chicken waste.
So that's okay, well, if I buy that and take that out,
Yeah. If you can, the demonstration is what is the reduction in nutrients compared to what was there before. You have to establish a maintenance agreement to make sure that, you know, next year the chickens don't come back, right? What MDE is saying is it's got to be taken out of production for 30 years, so you just really got to buy the property. But yeah, you can get significantly larger impacts there.
Mike, does this work in any other jurisdiction?
There are nutrient.
Does the secondary market really work?
It has worked in minor instances in limited areas. There's some areas, some watersheds, not the whole state in North Carolina, where they were able to implement the program within that watershed. And there are certainly other states that are now in parallel to us adopting some kind of program. Ours is aggressive. It's not as aggressive as it was back in the O'Malley years, but it's aggressive. I'm not yet convinced how it's going to work in reality. They're modeling it on a system that exists for air emissions from power plants, right? The power plants in the whole PJM area, which is basically the mid-Atlantic plus a bit of the Midwest, can trade emissions. So a coal plant can buy some reductions at another plant, or a gas plant can buy reductions at a coal plant. And so it's based on that. I think it's just more complicated because of the watershed factor. Being able to find somebody who's in your watershed.
You've got individual farmers, not power plants.
Yes, and they've got a process for registering them, but I think I've overstayed my welcome. So, thank you guys.
Thank you so much.